Yes, Madam Chair. Am I correct then that Attorney Mandel is seeking to have all affidavits submitted on our behalf, all papers struck from the record? Is that correct?
It would appear that that is the point of order that is being argued.
Okay. It's my understanding that that substantial compliance was met here by having the complaint verified by the co-candidate, vice presidential candidate. And I believe that she had the authority to verify the complaints submitted by the parties.
And what do you base that on?
Being a party to the action itself, being one of the named people that the complaint was directed at, and therefore she should have the right to file papers, and she did. Directed at the complaint or the response to the complaint accordingly.
Do you wish to make any other argument based on the language of 2.072B?
And therefore she should have the right to file papers, and she did. Directed at the complaint or the response to the complaint accordingly.
When you're ready for discussion, I have some questions.
Absolutely. Do you wish to make any other argument all opportunities are given based upon the unusual posture of a point of order in the beginning? So I'm going to allow Mr. Curran to take a quick look at the administrative code, and he can make any additional arguments, and then to take a quick look at the administrative code, and we will begin our process of contemplating the point of order. Attorney Curran?
Yes, Madam Chair. In looking at 2.07, parent 2, parent B, being one of the named people that the complaint was, when we're dealing with a president and a vice presidential candidates and nominees, that the singular would encompass both of them, and that they are treated as a team when it comes to analysis under this section, and that Ms. Tidball or Mr. West could verify a complaint on behalf of the other. That's the way the nomination papers were submitted, and I believe it's appropriate. That's the complaints against them were partnered up, and I believe that the singular there does reflect the plural.
All right, thank you. Commissioner Knudsen.
When I first read this complaint and the response, I took note of at the top of the response, it said respondents, plural possessive respondents, something like combined complaint or consolidated complaint. And I gave that some thought. I mean, I guess I'd like to hear from our staff attorney if there's any precedent for us, not accepting a response in this kind of a situation where it was consolidated. One of the candidates signed, the attorney, the other has signed. Is there any kind of precedent for us not accepting that response in that kind of a situation?
Yeah, that's a good question, Commissioner. I'm not aware of any precedent. It is interesting that, we generally don't get challenges when you have joint nomination papers, right? So both candidates appear, they kind of run as the ticket, right? President and vice president. So that does present, a little bit of a unique, scenario there. It's usually not an issue that comes up because it's always the singular candidate that is responding, to those verified complaints with a verified response in most instances. So to think of, has it ever happened in the last, 20 or 30 years? It's possible, but I cannot think of any. I'm not aware of any cases in which that has occurred.
Okay.
Commissioner Mandel, you have a question?
Yes, I think after hearing what Nate says and so forth and hearing the arguments, I'd like to make a motion that we continue with the hearing as planned and disregard the point of order that the gentleman for the challenger has.
I second the motion.
Is there a discussion from any of the other commissioners on that? All right, then I will call the vote. The motion is to deny the point of order and proceed forward with the challenge. Commissioner Bostelman,
Aye.
Commissioner Glancy,
Aye.
Commissioner Knudsen,
Aye.
Commissioner Spindell,
Aye.
Commissioner Thompson.
Aye.
I vote aye. The point of order is denied. You had a second point of order, Attorney Mandel?
I do, Madam Chair. Thank you very much. This one I'm stating primarily for the record. I understand that the staff has already discussed this with the administrator and with yourself, but it is our position. We did submit a reply brief within 3 calendar days after the response was submitted. It came with a supplemental affidavit. We do believe those things should be part of the record. The rules of this commission neither require nor prohibit reply briefs, but properly read, they weigh in favor of accepting such briefs. Section 2.07, subdivision 4 of the Wisconsin Administrative Code, EL, says that the commission, quote, shall examine any evidence offered by the parties when reviewing a complaint challenging the sufficiency of the nomination papers of a candidate. It's also the case that general principles of Wisconsin law weigh in favor of accepting such a reply brief. Under general principles of Wisconsin law and Anglo-American law, the party bearing the burden of proof gets the first and the last word. I can cite you 7th Circuit case, Wisconsin Supreme Court cases, treatises. This is just a general principle of law. It is black letter law that applies any place there is not an express exception. This structure aligns with fundamental principles of due process, which do apply to Wisconsin administrative hearings like this one, according to the Wisconsin Supreme Court in the Union State Bank case at 142, Wisconsin 2nd, page 126. The real concern of due process is about fundamental fairness, as the US Supreme Court and the Wisconsin Supreme Court have held. We did not in any way attempt to prejudice the other side by filing our reply brief, but we did think that we are entitled, where there is time before the commission hearing, as there was here, to have the last word. We think that brief should be part of the record in case there is litigation that goes forward. As I said, I understand that the staff, the administrator, and yourself have conferred upon this, and we just want this objection and this point made for the record. I don't necessarily expect that there will be a reversal of the decision that was communicated to me earlier.
Attorney Judnick, do you want to explain the rationale here?
Sure. It's not real complicated. I think the basis for the decision, when the reply came in, is that these are kind of the standard procedures of the commission. The commission has never allowed a reply brief in these challenges before. It's not something that that is specifically prescribed in the administrative code section that talks about it. It says there's a complaint, there's a response, and then the commission makes the decision with or without hearing. So based on the past practice, based on what the administrative code says, that was the basis for why those replies were not accepted, because they were not part of the usual practice. So I understand Attorney Mandel's arguments. However, we're not going to deviate from the normal practice and what our commission rules state. So that is why it was that's why it was determined that way.
Okay.
When the replies were sent, I did send a note to the commission saying that they were filed, but we did not provide any of that information, not as to prejudice any of the commissioners to see a reply that's not currently on the record.
Thank you. Commissioner Knudsen?
Madam Chair, if we had been having this meeting in person and the complainant and the respondent were both there in person, and if they had brought additional written materials and handed them out to them, would we not have accepted them and read them during the course of the hearing? I pose the question to you, but you may actually want to defer it to the staff, I guess. But wouldn't it be allowable, acceptable, and has happened in the past that additional written materials can be brought in during the hearing, or written materials can be brought in during? Is our past practice that we rule on the record as it was created with only oral arguments? That's my question.
I will speak as to my own recollection that as opposed to other matters before the commission, I am not aware of us accepting additional affidavits or evidence of that type during a nomination ballot challenge, as opposed to other matters before the commission. And one of the other rationales that I think is important here is the ability to properly review and prepare for today's hearing, which is challenged dramatically when we have 1,600 pages and such an extraordinarily tight time frame to do it. Are you making a motion to admit those? And
I wasn't really. I was just trying to understand if we had historical precedent for doing that. If part of what was different here is that we're on Zoom and not in person. If they had brought them with and asked to distribute them, would the complainant have been told no? That's my question, I guess, for Nate. Are you telling me that's never happened before, that they brought additional written materials on the day of the hearing?
I don't believe the commission has accepted that in the past, or the GAB accepted that in the past. Information that we, generally distribute to the challenges that occur, the larger challenges that occur generally during the June meeting. There's specific information, because of the tight time frames. Here there was a little bit more time, but not a large amount of time, that you get your shot with the complaint, you get your shot at the response, and then you can discuss whatever's in the record, at the hearing, and then the commission can decide. In that case, you have a June 1 filing deadline and a June 10 certification deadline in most cases. So you're, scrambling quite a bit even to get information. You throw an extra reply in there of how many additional pages and other affidavits and other evidence. It gets to the point where, it's difficult to manage and difficult for the commission to consume and figure out, what's going on. So I think that's historically why, it's cut off. That's why the rule is written that way. You get the one shot on the complaint, one shot on the response, and then the commission hears the matter. So I don't believe we accept, like tag along documents. Oh, I've got an extra affidavit here. No, that just has not, it's not been the past practice.
Okay.
Bill?
I just have a question for Nate. Actually, what the paragraph, what is it, 2.07, 2.4 actually says, it says the filing officer shall examine any evidence offered by the parties which review the complaint challenging the sufficiency of the nomination papers and so forth. Wasn't that actually done? Didn't Megan and the staff examine the evidence? And did we meet the requirement of that paragraph by the staff examining? It doesn't say the commission has to examine.
As far as the original complaint and the response?
No, I'm just talking about the final one. It says the filing officer shall examine any evidence offered by the parties when reviewing a complaint. And so you're reviewing everything. And this is a document, a third document. Obviously, you've all reviewed it. So it doesn't say the commission has to do that. That's just a question. Maybe there isn't a good answer to that.
I think that that statutory, that administrative code section refers to the complaint and the response. It doesn't contemplate the reply.
Right. Mm-hmm. Okay.
And as a matter of fact, I would also add, if I may, that we were actually very careful not to examine any additional material after the deadline, as not to bias any of the decisions that were made.
Okay.
That's correct. I have not looked at the reply, and so I don't even know what is actually in there. As a matter of course, it just, it didn't seem like it was an appropriate filing at the time.
Yes, Commissioner Knudsen.
Well, my concern here is really just that we try to stick to our precedent There's been plenty of chance for us to have been challenged in court over our past practices and administrative rules in the past, but I don't think we have been challenged on that. My concern is if we deviate from that now, do we open ourselves up that, you know, other complainants during this hearing or future hearings or maybe even past hearings go to court and say, I didn't get a fair shake because you're doing things differently now. So my motion would be that we deny the point of order and not accept the reply.
There's a motion on the floor. Is there a second?
I'll second.
Commissioner Spindell seconds. Is there any further discussion? I will call the vote. Commissioner Bostelman,
Aye.
Commissioner Glancy,
Aye.
Commissioner Knudsen,
Aye.
Commissioner Spindell,
Aye.
Commissioner Thompson.
Aye.
I vote aye. The vote is 6-0. The point of order is denied. We will now proceed. Are there any other points of order, Attorney Mandel?
Not respecting this this complaint, Madam Chair.
Okay. Then Administrator Wolf will begin the time, and you have 10 minutes to present to the commission. Go ahead.
Thank you very much. May it please the commission. The nomination papers submitted on behalf of Mr. West and Ms. Tidball were untimely. They were filed after 5 p.m. as the staff recommendation reflects. Statute 8.20, subdivision 8, section AM, says that nomination papers must be filed not later than 5 p.m. And Wisconsin Administrative Code EL 2.05, subdivision 2 specifies, quote, to be timely filed, all nomination papers shall be in the physical possession of the filing officer by the statutory deadline. The papers are not transferred to the physical possession of the filing officer merely when they enter the building in which the commission's offices are held. The deadline for filing nomination papers must be strictly observed. The Wisconsin Supreme Court has so held over and over and over. I think most directly as it respects this discussion in the Stearns case, STEARNS, at 257 Wisconsin Reporter 445. The evidence shows that the filing was not submitted by the 5 p.m. deadline. By her own admission, Attorney Ruland was in her car at 4:59 p.m. That's in paragraph 6 of her affidavit on page 928 of the commission materials. Ms. Ruland exited her car a couple of seconds after 5 o'clock. You can see that in Exhibit A to the Remacher affidavit at 3 minutes and 4 seconds in the video. It took her, as the staff found, between 14 and 20 seconds to reach the building door. You can see that in Exhibit A to the Remacher affidavit at around the 3 minute and 18 to 3 minute 22 second mark. Ms. Ruland's colleague, who held the bulk of the nomination papers, followed her about 8 or 9 seconds later. You can see this too in the video that is Exhibit A to the Remacher affidavit. This means the nomination papers were not in the building by 5 p.m. They were still on the sidewalk outside. The staff memo says that the staff believes that some of the papers first got to the building door at about 5 o'clock and 14 seconds. That's on page 13 of the staff memo. And this fully accords with the video that is Exhibit A to the Remacher affidavit. The staff notes that as well on page 13. Ms. Ruland's affidavit states that she believes that she was in the commission office before 5 p.m., but that is irrelevant. It is not supported by the evidence. It's in paragraph 7 of her affidavit, by the way, on page 929 of the commission materials. And as Wisconsin courts have held, quote, subjective opinion is not relevant, end quote, on a question of objective fact. Time is an objective fact. When the statute says 5 p.m., it means 5 o'clock p.m. Arriving before 5 o'clock, 5:01 is not sufficient. 5 p.m. occurs when the minute hand moves from 4:59 to 5 o'clock. This deadline has been established in case law for more than 70 years. The Elections Commission itself recognizes the strictness of the deadline. It's in the staff memo. On April 10th of this year, this commission discussed the importance of strict adherence to these deadlines. I would point the commission to the timestamp of 31 minutes and 4 seconds to 37 minutes and 23 seconds in the video of that public meeting, where the commissioners discuss at length. And I believe that that Commissioner Knudsen and Commissioner Spindell in particular talked about their own personal knowledge and experience of people who are very, very close to the deadline, but just miss it, having their papers turned away. The statutes that regulate nomination papers are mandatory, not directory. This commission held that earlier this year in the Jim Sullivan case, case number EL 20-05, decision and order issued on January 21st. And at the February 27th meeting of this commission this year, the commission passed a motion saying, quote, the substantial compliance language in Administrative Code EL 2.05 does not apply to procedural requirements for circulating and filing nomination papers and other election petitions. Procedural requirements involve acts done to the documents and include the time and place of filing, end quote. That is on page, I believe it's page 31 of the commission materials packet for that meeting. Sorry, it's on page 30, numbered page 30 of the materials for that meeting, which was only a few months ago. Even if any time of filing before 5:01 p.m. were timely, and it's not, the nomination papers at issue here were late. Ms. Ruland entered the building no earlier than 14 seconds after 5 o'clock. We've discussed that being in the video and the staff memo. Her colleague followed 8 or 9 seconds later with the bulk of the papers. That left them no more than 36 seconds to walk the length of the first floor, to wait for the elevator, to ride to the third floor, to wait for the doors to open, to walk to the main desk of the commission, and to transfer the papers to the filing officer. That cannot happen in 37 seconds. The staff memo reaches that conclusion on page 15. The video from Matt Smith at WISN 12 News shows that 27 seconds passed between Ms. Ruland's colleague entering the building and the elevator doors closing on the first floor before the elevator even began to rise. The papers were in the elevator and not in the filing clerk's possession at 5:01. In addition, as the staff memo notes, once the papers entered the commission office, Ms. Ruland and her colleagues spent several minutes organizing and numbering the pages before transferring them into the physical possession of the filing officer. The papers were late. Under Wisconsin law, they cannot be allowed. The respondent's approach here tries to eliminate this bright line deadline and force this commission to engage in making unnecessary, involved, and potentially arbitrary factual and equitable determinations. That is a very bad idea. It invites litigation. It creates confusion where none now exists. The respondents attempt to shift the blame for their late filing. They claim that because the doors were locked, it's not their fault. But Ms. Ruland admits that she knew, and she had spoken with the staff earlier in the day. She knew the doors would be locked and she would need to arrange for access. The respondents claim that an overly aggressive media and a Democratic operative caused delay. This is not true. The Remacher affidavit, Exhibit A, the video shows there was no interference. Mr. Smith's news video shows that no one obstructed Ms. Ruland or her colleague. And I would note that this is mere rhetoric in the response. If you look carefully, commissioners, at Ms. Ruland's affidavit, she does not say she was obstructed. She simply says there were other people outside the building. Ultimately, the respondents have only themselves to blame for the lateness of their filing. Every signature on the papers, more than 2,000, was collected on August 3rd and 4th, the last 2 days of the 35-day window. It is no surprise that there was chaos at the end in trying to get them filed. The staff itself cannot extend the filing deadline. We know that. There is no argument that they are ratified as timely simply because the commission staff did not force Ms. Ruland and her colleague to keep the nomination papers, but took possession of them. And the constitutional arguments raised by respondents have no substance whatsoever, as addressed by the staff memo. That's not even the only reason the nomination papers should be rejected. There are improper circulator certifications that when you take care of those, that reduces the respondent's signature count well below 2,000. Several circulators falsely certified. As the commission knows, every circulator must certify that they personally know that each elector, quote, signed the paper with full knowledge of its contents. That is in Wisconsin statute section 815, subdivision 4A, and it is incorporated to this process for independent presidential candidates by Wisconsin statute 8.20, subdivision 3. More than 100 electors signed only because the circulator affirmatively misrepresented the purpose or meaning of the nomination papers. That's in paragraph 22 of Mr. Remaker's affidavit on page 742. If the commission would like, I'm happy during question and answer time to walk through each of those 12 circulators who falsely represented and what affidavits we presented in the 45.5 hours that we had from the time we got those papers from the commission to our deadline. We got 24 affidavits from individuals who swear that they were lied to in different ways and in different circumstances that make those certifications false. If those certifications are false, if the circulators falsely attested, not only those signatures, but all signatures on pages certified by those circulators must be struck.
Thank you. Thank you, Attorney Mendel. Attorney Curran, you will have 10 minutes to provide us with your argument. Go ahead.
Yes, Chair. If before my time starts, if I could make a point of order, please.
You may.
Yes, I would like to dismiss the complaint against the campaign with regard to timeliness as not having jurisdiction. And I'll develop that argument if you so desire. But the complaint was based under 5.06 and 5.06 parent 1. And 5.06 parent 1 describes a situation where a complainant has a problem with the actions of a election official. And that's exactly what is going on here. And therefore, the person that this should have been filed against is not the campaign itself, but against the filing officer who took the papers. What we do know is that a filing officer accepted the filing. I believe we know that a filing officer has no authority to accept untimely filings. No steps were taken by the filing officer himself to correct any perceived mistakes by the filing officer. No evidence that the filing officer believes he made a mistake in accepting the filing is in evidence. There's no clear and convincing evidence that exists that the filing was itself untimely, in that there's no timestamp, there's no official timekeeping mechanism, there's no rejection.
This is not a point of order. This is your response to the challenge, sir.
Well, it's before I get to the response, this is to try to have that the timeliness challenges were not supposed to be against the candidates themselves. They were supposed to be against the filing officer, and therefore the jurisdiction doesn't exist.
Hold that for a moment. Commissioner Knudsen, you had a question on this.
Well, this is another area I thought about some, and I discussed briefly with Administrator Wolf the other day. In the staff memo, this agenda item has staff memo starting on page 1 through page 33, deals with the complaints filed, the 5.06 complaints. But then page 34 deals with the decision of the commission as to whether the filing was timely and sufficient, enough signatures and so on. I don't think I'm misstating. And what I said to Administrator Wolf, or what I was kind of curious about, is it occurred to me that maybe we should have been voting on part 34 first, and then an aggrieved party as to the outcome of that decision would have had a chance to file a complaint against us in regard to our decision. Because really we haven't made a decision yet for them to complain about by one way of looking at this. And I hope I'm being clear, but if you understand what's going on is we have two different decisions to make here today. Had there been no complaint, it would still be our role as the commission to make a determination in regard to each of the candidates who filed a declaration of candidacy. Did they submit enough nomination papers on time in the right place and manner in order to gain ballot access? That's our role. We do it every time with every candidate that filed a declaration of candidacy. And if any member of the public or one of the candidates doesn't like a decision that we made, you know, they can file a complaint. Now, maybe I'm confused or misstating that, but I think that's what the attorney's getting at here is we may have this somewhat backwards. Nate, can you, or can any of you see what I'm getting at there?
I think under 8.30 sub 1, you know, the commission has the authority to determine whether candidates have met all of the qualifications, and they have the ability to determine whether they should appear on the ballot or not. So whichever order those go in, I believe, you know, that's ultimately the commission's decision here. You know, it's not the commission staff's decision. Commission staff makes recommendations, but ultimately the commission has to decide, you know, whether those requirements have been met or not. So I understand, you know, the potential confusion there, but I don't really think it is. I think you know, the decision is up to the commission, and they have the ability to, you know, accept those challenges, you know, to those papers because they were filed, you know, and you know, there's a belief that they were filed untimely, and they're, you know, the parties have the ability to offer evidence to support that claim. But the commission also has the independent authority, I believe, under 8.30 to make that determination regardless of the challenge. So I believe, you know, it's up to, I think, the commission how they want to handle that, but I don't think there's anything necessarily improper with the order that these are being addressed in.
Commissioner Thompson.
I think it's absolutely within our jurisdiction to decide this question. That's what we're here to do. We're here today to decide what candidates go on the ballot. And so I would move that the point of order be rejected and get on to the merits and get on to deciding who's going to be on the ballot.
There's a motion on the floor. Is there a second?
I'll second.
Commissioner Knudsen seconds. Is there further discussion on the procedural posture of hearing the matters at hand? All right, I will call the roll. Commissioner Bostelman.
Aye.
Commissioner Glancy.
Aye.
Commissioner Knudsen.
Aye.
Commissioner Spindell.
Aye.
Commissioner Thompson.
Aye.
I vote aye. Point of order is rejected. Attorney Curran, is there any other point of order?
I don't think it will, I don't know that it needs to be reheard, but 5.06 parent 1 contemplates proceedings taking place under chapter 227. And I would say that this doesn't meet those standards. Other than that, I don't have anything else to add to the point of order.
Okay. You may begin your time to argue.
All right, thank you. Good afternoon, Madam Chair, Elections Commission, staff, and opposing counsel. My name is Mike Kern. I represent the Kanye 2020 campaign, and this is I guess it's the first now of the two cases that we're here for. As I made in the point of order, I think what this is in large part is a challenge to the sufficiency of the timeliness, and it's really not clear that that can be made by challenging the submitters themselves. The facial sufficiency of papers submitted by a challenger certainly is within the realm of a challenger being suited to defend. But once papers are accepted, and in order to be timely filed, all nomination papers shall be in the physical possession of the filing officer by the statutory deadline. What is a filing officer supposed to do if he concludes that the nominator papers are not timely filed? They are supposed to reject the filing. This is what occurred in both of the similar cases cited by both parties in this case, namely the state versus the Conlon versus Zimmerman and the Stearns versus Zimmerman cases. In both of those cases, a filing officer deemed the filings untimely and refused to accept them. And therefore, the Zimmerman is the party that the aggrieved party had to pursue relief against. A successful challenge against the sufficiency of the timing of a filing then therefore necessarily requires direct information from the filing officer. We don't have that here. What we have is hearsay. We have no official evidence or statements from anybody related to the filing officer. All we have is hearsay within hearsay statements, and also the staff recommendation that it brought in additional information not in the record, and that's simply insufficient to meet a clear and convincing standard. We know that the filing officer accepted the papers. We know neither the filing officer nor any commission staff took any steps to challenge the sufficiency of the filing. We know no one challenged the filing officer directly as required by 5.06. There is some skirting of this, I believe, by the staff indicating that they knew that it would be challenged in an abundance of caution. However, that's simply an inappropriate reason to accept filing papers. Had there been no challenge, there would be no question as to the timeliness, because nobody, it seems that it should have been something that was fixed by the department itself, and no steps were taken by the commission itself. Now I'll leave those arguments. They were already made in my point of order, and get to the more esoteric arguments about what it means to be no later than. But when we're talking about time periods, no later than includes the time frame in the reference that were used. For example, no later than Tuesday does not mean prior to Tuesday. No later than Tuesday means all of Tuesday. And therefore, no later than 11:59 would mean all of the minute of 11:59, at least when it comes to drafting, filing of documents. And to make 5 p.m. quote unquote late, the proper language would be before 5 p.m. or prior to 5 p.m. or not later than 4:59 p.m. But no later than 5 p.m. does include the full minute. At the top of page 13 of the staff memo, and I'm sorry, I did not see the part about referring to the correct page on this, but it is the staff memo, and I assume everybody has that handy. Staff has concluded that the time of 5 o'clock and 14 seconds cited by Attorney Rulin is the time she walked into the building. That conclusion does have secondary support, but it actually misstates what Attorney Rulin swore to. It is in paragraph 14 of her affidavit, and she says in part, when the filing officer arrived at the main desk of the commission, he stated that the petitions were filed at 5 o'clock and 14 seconds, and he would need to confer with legal counsel about the timing of them. In the next paragraph, Attorney Rulin confirmed that all of the documents were accepted and the receipt to her did not have any timestamp. And as at the top of that same page, the staff again cites 5 o'clock and 14 seconds as the time of filing. We simply don't have that in a clear and convincing evidence to that conclusion. And in fact, that he refers to the response using that time throughout its response, but in the response, the first time it gets mentioned is said, even if true, and therefore there's no concession by the campaign that the papers were actually filed at 5 o'clock and 14 seconds. Third paragraph of the staff memo, it is correctly stated that the candidate has the responsibility to assure that papers are in compliance with the statutory and legal requirements of Election Code 2.051. However, in the absence of official timekeeping mechanism, and in the absence of the denial of the papers themselves, and in the absence of the filing officer who took the papers taking any subsequent steps to correct any perceived error in accepting the papers, and in the absence of the filing officer's assertion to the contrary at the timeliness of the filing, there's simply no way to prove that the papers were not timely filed when they were accepted by the filing officer himself. And surely with all of the challenges requiring clear and convincing evidence to the contrary, the acceptance of the papers should trump all of that conclusively. At the bottom of page 13 of the staff memo, in its third argument, they conclude that the paperwork was not present in the commission's office before 5 p.m. And that's exactly my point I made previously, that before 5 p.m. is a clearly, the language is clear what that means. And had the language been before 5 p.m., then the campaign would not be making any argument that 5 o'clock and 14 seconds would be within the prescribed requirements of filing. Within the same paragraph, staff claims to being in the office where the filing is required within the required time period is sufficient to meet the deadline. We agree, the campaign agrees, because it would make no sense that one could enter at 4:59 and be stopped from filing the papers because others were in front of them filing papers themselves. And because we know, or at least we believe, that Attorney Rulin stated that she was there at 4:57, that goes to the strength of the argument that she could have been in the office before 5 o'clock had the doors not been locked. Page 14 of the staff memo, various arguments to refute the campaign's arguments are made, but had the filing officer deemed the campaign's filing untimely, delays caused by factors outside of the commission's control, such as stoplights, that would have been, the campaign would have to seek relief in a different manner in a different way. And likewise, if the delay could have been mitigated by the commission, such as the locking of the door, just because we had notice, or just because Attorney Rulin apparently had notice of that, that doesn't fix the constitutional problems. And the case for that would be Richmond Newspapers versus Virginia, 448 U.S. 555, 1980. At the top of page 15 of the staff memo, the fourth argument made is that the nomination papers were not in the possession of the filing officer by 5:01. That's contradicted by the hearsay that we have. I agree, we don't know conclusively. That's kind of the whole point of the argument, but I simply don't believe that's a correct conclusion based on what is stated within the affidavit, and that's the only thing that we have that is clear, that is presented as to that, who had possession of them. In the middle of page 15 of the staff memo, a fifth argument is made that acceptance of the nomination papers after the filing deadline does not ratify the filing. It says as timing, it means as timely, but this is circular because the campaign does not concede that sufficient evidence actually exists that the papers were accepted after the filing deadline. Again, it comes back to the point, they were accepted and they cannot be accepted after the filing deadline. And without there being any challenge against the filing officer himself, the only fair, just presumption is that accepted papers are deemed timely by the filing officer and therefore can only be challenged with clear and convincing evidence that the filing officer erred and by taking an action against the filing officer directly, as I stated before. I've got some quick not later than examples that are in the statutes. One is 138.14, parent 14, parent D3, where it talks about a payday loan. I agree this is outside of our area of law, but it says no later than 11:59 p.m. on the day that such notification is received. That is correctly drafted language to encompass the full day that follows the day in question. Another one is on 961.385, parent 2, and submit the record to the board no later than 11:59 of the next business day. It was, I'm not saying that the no later than 5 p.m. was supposed to be drafted the way it was, but certainly people became more careful when they analyzed what is going on with regard to a filing that gets near midnight and made the appropriate language. And it makes sense that everything, is that it? Okay.
That is. We're going to begin the part where the commissioners are able to ask questions of the parties. I do have a few questions for Mr. Curran as a preliminary matter. Ms. Rulin's affidavit does not note the fact that she had to number the pages. Is it in fact true that Ms. Rulin was required to number the papers?
I believe that was addressed in the memo itself, and that it looks like it is a requirement of the parties submitting papers, but it also looks like the papers will be accepted whether they're numbered or not. And if I've misstated that, certainly Attorney Judnick can correct me, or Attorney Mandel if he knows, but that's my understanding.
Attorney Curran, my question is, did she have to number the papers before filing them?
I have no knowledge of that.
Okay. A second question I had was paragraph 4 of her affidavit states her earlier instructions received from the commission that she knew that she was going to have to call when she arrived, correct?
I believe that's accurately stated. That's what her affidavit states, correct?
Okay, and it's your contention that even though warned, it was the commission's responsibility to do something other than warn her that she was going to need to call?
It is. It's my contention that that the building should have been held open to the public and that there should have been no hindrances put in the way of any party attempting to file papers.
What if the commission had informed her that the front door was under construction and she was going to need to walk around to the back? Would that have somehow allowed her to file her papers late?
I think it's an interesting question, first of all. I think that had the back door not been obstructed or locked, or had no measures been necessary to enter through the back door, I think that that probably does meet constitutional requirements.
What if it was really far away and you couldn't get there in 1 minute from 4:59 p.m.?
Well, I guess my first answer would be, it's not the situation before us here. Had it been the situation, I think it would be a strong argument that it was the candidate's responsibility to ensure the papers were timely submitted, and in the absence of obstructions or locked doors, they may not be able to meet their burden.
I do have one more question. Are you aware of any case law in the state of Wisconsin that has held that 5 o'clock means between 5 o'clock and 5:00:59 seconds?
To answer your question specifically, case law addressing that specific question, I don't have case law. I do have evidence within the statutes and within the electronic filing system that would support the conclusion that it includes the full minute, but not case law.
So you're not aware of any Wisconsin precedent that's held that?
I am not.
Okay. Ms. Rulin's affidavit does say that she believes she was in the office before 5, but not that she was in the office before 5. Why does she not state as a fact that she was in the office before 5?
Yes, I don't know. I'm not sure why Ms. Rulin stated what she stated in the affidavit, but I think one can assume that she did not know what 5 o'clock meant to the filing officer, and therefore trying to conclude what time it is simply outside of her knowledge.
Well, what time does she think she was there?
I'll let the affidavit speak for itself, if I may, Madam Chair.
All right. Finally, when, as lawyers, we file papers late, they're accepted, but they're filed on the next business day. Why would that not apply in this situation?
Yes, thank you for the question. E-filing requires that papers are filed by 11:59 p.m. and accepted by the clerk the next day in order to be considered filed on the day that they were submitted. And that is a very analogous situation to this. Any papers submitted at 11:59 and 15 seconds would certainly be deemed filed timely by the system itself. And therefore, the idea that by 11:59 would restrict the time period in question, it certainly does include the full minute after the named time. And I think that's the same thing. The same analysis applies to a no later than situation.
I think you misunderstood my question. If you miss it, and let's say under your hypothetical, and I'm not sure I agree with the 11:59 and seconds part, but let's say that you file it at 12 midnight and 1 second, the documents are filed, but they're filed and considered filed on the next business day, correct?
That's correct.
So why aren't untimely papers received by the Elections Commission considered filed the next day.
Yes, and I can say this, Madam Chair, I don't know if they are or aren't. I don't know what the procedures are. I would assume that untimely filings are simply not accepted.
And why would you assume that?
Because if they were improperly accepted, they would have to take steps to correct that acceptance of the papers themselves.
And what do you base that on?
Yes, I base it on the fact that their responsibility is that they follow the law and do not, and the filing officer's responsibility is to ensure that with regard to the timeliness of filing, that they ensure that that aspect of the papers is taken care of and is done properly. They are in sole control of that decision as far as I can tell.
Do you have any support for your contention that the filing officer is prohibited from accepting the filing and assigning it filed the next day?
I do have evidence that the filing officer does not have to accept the papers, and that would be the Zimmerman cases that both sides have filed in behalf of different arguments, that the papers were rejected by the clerk or by the filing officer, and therefore the parties aggrieved had to take additional steps to challenge that decision and determination by the filing officer.
I agree that we would have had the authority to reject it at the door. What I'm asking is there any support for the contention that we could not accept them but mark them filed untimely, as in the next day?
I believe that that possibility, I believe that that may be within the realm of what a filing officer is permitted to do, but they would have to take steps in order to correct such a what I guess I would put in quotes, a mistake, and no steps were taken here.
What steps are required, and point me to some sort of statutory obligation of what the filing officer would have been required to do?
I think that that may go back to 5.06, and it would be that an action of the official or a failure of the official to act with respect concerning nominations, I think you would have to challenge it under that. There may be other ways that the staff can take steps to do this, but if that is the proper place where it goes, parent 3 of 5.06 states that the ability to fix any problem has to be done within 10 days. And I guess I would say that the commission is better suited to know if the situation has arisen in the past than I am. And maybe Attorney Judnick could answer the question whether or not they've taken steps to correct a perceived mistake on behalf of the commission.
Why do you say perceived mistake? Are you saying that accepting a filing and marking it filed the next day is a mistake?
And if I can be clear on what you're saying, Madam Chair, when you say, is there evidence that this was filed and marked on the next day, or is this a hypothetical? I'm not aware that these papers were actually marked and as filed on the following day.
Well, what I'm asking is, even if received late, people receive things all the time, right? We can file things late all the time. They are received. They're even filed with the court by way of example. But the date by which they are considered filed is determined by the receiving entity, clerk of court, or in this case, the Elections Commission.
I agree, and I would state that the only evidence that we have that these papers were filed is that they were filed timely because the election official, the election officer accepted them, okay, with no indication that he deemed them untimely or filed the following day.
Thank you, Attorney Curran. Commissioner Knudsen, I believe you wanted to go next.
Thank you. Attorney Curran, Administrative Code EL 2.05 sub 2 requires that the nomination papers be in the physical possession of the, I don't have it in front of me, but of the filing officer. And yet we're talking a lot about what went on at the door of the building. Does the affidavit claim, or is there somewhere in evidence that the candidate or the candidate's agent somehow transferred physical possession at the door?
I don't know. I don't know if there's any evidence either way with regard to that question.
Because my understanding in reading all the papers and the staff memo is that the phone call at 4:57 actually went directly to someone who was standing right near the door. And so I mean, there's video of them going back to their car and waiting, but it appears to me that there was somebody waiting by that door to open the door. There was really no delay upon arrival at curbside. There was no delay by that locked door because someone was standing there waiting for them, who then escorted them to the elevator, which was waiting, and escorted them up, at which point the possession was still retained while the candidate's attorney proceeded to add the required page numbers. And at which point, after all of that had taken place, then the candidate's attorney transferred possession to the filing officer. Since EL 2.05 carries the weight of law, the law requires that they actually be in physical possession. It seems to me that there's no evidence that happened, but in fact, there's evidence to the contrary that transfer of physical possession did not happen before 5 o'clock or 5:01, but happened sometime after that. Do you see this differently, or would that be an accurate understanding of the facts?
I think that the fact that we aren't clear on that point proves the point that the only actions that truly matter with regard to the question of timeliness come down to the actions of the filing officer. And as a sort of an analogy here, when in boxing, when a boxer is knocked down, you don't get 10 seconds to get back up, you get a 10 count. And the person in control of that is the referee. And in this case, I believe that the filing officer serves as the referee, and they determine whether or not the 5 p.m. deadline has been met or not. And here we have a situation where it does not appear that the filing officer deemed this untimely.
So just as a follow-up question as to the 5 o'clock, it seems to me that just common sense and common understanding would be that all the designations of times that start with a 4 are before 5 o'clock, and all of those that start with a 5 are after 5 o'clock. And you could go to infinite number of decimals and that would be the case. So you've used the example of 11:59 in cases where the statutory requirement is that it happen on a certain day. By the next day would be considered late, on that day was considered timely, and then the statutory construction is that it says not later than 11:59, which is exactly that same situation. Any time that it came in that would be 59.9999 would still be timely. But any time that started with a 12 isn't timely. It's after midnight and it's actually the next day. To my understanding of it, it's pretty clearly the same thing. 5 o'clock is 5 o'clock. So I understand you're trying to make an argument that 5 o'clock is 5:01, but it just seems to me that, you know, everything that starts with a 4 is before 5 o'clock, and 5 o'clock's the deadline. Maybe I'm just common sense and not a lawyer, but that's the way it seems.
No, Commissioner, to respond to that, I frankly believe it is a drafting error. And I think that it's correctly defined when people are contemplating how to define before midnight. And they say it must be filed no later than 11:59. And I think that there's just a little bit of carelessness there. You can see it in the Zimmerman decisions where they conflate before, they conflate within, and so forth. And that by saying no later than 5, they have added an additional minute, which is how I'm not familiar in law with seconds mattering when it comes to regards of timeliness. It is simply times or minutes and larger components of time. And if, the fractions of a second are simply part of what you would refer to if you're looking at a clock. A digital clock says 11:59, and that is what time you would report to somebody. You wouldn't round up until the clock itself changed.
Attorney Curran, if you set a timer on your phone to go off at 5 o'clock, when would it go off?
It should go off at 5 o'clock sharp, as soon as the clock turned to 5.
5, 0, 0, 0, 0, so on.
Yes.
So if we had set a timer to go off at 5, would the papers have been in on time or not?
Well, the first response would be that's for the filing officer to determine. But to answer your question directly, I still think that the way the language is set forth, the person would have until 5:01 to file the language, because there it would not be seen or deemed later than 5 o'clock based on the language used and the way other statutes similarly use that language. And again, that's because I think that the time period in question matters, and that's why no later than Tuesday means all of Tuesday.
Question for the staff then, and then I'll be done. Procedurally here, the staff memo introduced things that were sort of testimony by the staff in a couple of places, things that I didn't see in either of the affidavits. And so is it appropriate and proper for us to essentially query or take testimony from the staff as to what happened?
I'm assuming that's for me, Commissioner Knudsen.
Yes.
If the commission desires, that is certainly something they could do. I would offer, however, that the commission staff has no real interest one way or the other. I mean, they're giving their best advice to the commission as to what they believe happened that day. So when there are some statements there that talk about what happened, it's relaying that from the individuals exactly what happened. So when we're talking about, a staff member was standing at the glass door receiving the phone call, that comes directly from the person that was, standing by the glass door answering the phone. So if you believe that is helpful, it's never really been done before. But if that is helpful for the commission, I don't know if we could handle it right specifically now, because I don't know if those individuals are necessarily available. However, but there is no. So when the filing officer, quote unquote filing officer, it's the staff, but it's really the commission who's making the decision. So what's happening here is the staff who were on the ground are relaying and providing the information to the filing officer here to make that determination. So, some of the statements, absolutely, some of the information that is for the commission to weigh and decide whether they want to accept that information or not. But that is the role, I believe, of the staff when they're making their recommendations. They're providing the commission the information that they know to be true, and the commission is free to then weigh and make those determinations based on what's before them, coming from the staff that were actually, on the ground when those papers came in.
Well, let me pose my question, and you can tell me if the question's out of order, or the chair can tell me I'm out of order. Here's my question. I believe the law and the rule says that the papers needed to be in the physical possession of the Elections Commission no later than 5 p.m. My question is, who took physical possession and when did they take physical possession?
Do you want staff names?
To me, that's the crux of the problem here. And if that person is available to talk with us, I mean, it seems to me like if our job is to find the facts here and find out what's true and right and make a decision that's fair, that's the crux of this. That's what we need to know. Not what time were they on the sidewalk or in the lobby or in the elevator or any of that. You know, who actually took possession? Like, hey, now they're in the hands of the attorney and now they're not. And that happened at a particular time. When did it happen?
Administrator Wolf, could you perhaps address that?
Sure. One of the things that perhaps I can add to this conversation is just a discussion of our usual practice, not just for this particular deadline, but for all filing deadlines in our office. So staff in our office is instructed on filing deadlines to stand and monitor the doors for candidates that may be entering, challenges that may be entered in our office, so that there is no delay in somebody being able to enter. And that was what staff was directed to do on this particular deadline in accordance with our usual practice. I myself have played that role before, as has Attorney Judnick and others in our office, where we always will have a staff monitoring those deadlines to ensure that it's a smooth process for candidates. Staff is also instructed that they are not the decision makers in these cases. So if there are questions of timeliness, if there are questions of validity, the staff's role is to make recommendations, relay information to the commission as the ultimate decision makers. And that is how we operate in our office always. Staff is instructed that they are not to be making any sort of decision based on timeliness in the office. So that's the role of the commission, to relay the facts and the recommendation to the commission, but ultimately the commission is the one making those determinations.
Okay, who took physical possession? Was it the person that met them down at the door and they walked up, and then once they were up at the desk, there ultimately was a transfer, or were there somebody else sitting at the desk waiting? When did the actual transfer of physical possession take place?
It's my understanding that we had a staff person at the door downstairs who escorted the person up to the front desk, where they met another one of the election specialists who gave the usual information to the candidates about what needed to be done in order to file the nomination papers. And then that election specialist, the two election specialists, took possession of the papers after that had been done. And if you would like their names, we certainly can do that too. I don't know if the chair feels that that's relevant.
Well,
I think we should have I am protective of our staff because, they are not always expecting such things, but I think it's of some importance. Sure. So what is the identity of the two staff members?
Sure. Cody Davies, one of our election specialists, is the one that was at the front door and escorted them up to the third floor. And then Riley Williams was also at our other election specialist, who was there receiving the papers.
So Commissioner Knudsen, before we decide if we're going to take testimony, I think I'd like to hear from the other commissioners as well, and perhaps return to your question after we've had a chance to discuss that a little further. Would that be agreeable?
Absolutely. I don't want to belabor the point, but I'm still waiting to hear what time was it when that physical transfer happened. You can't have it both ways, staff. You can't say you're not the deciders if it's timely. We are. You just collect the facts and turn it over to us to decide. I'm still waiting for the facts on that. I think I can infer. I've gone up to the third floor before. You can't do it too fast. I don't know what the world record for that trip is. So I can infer that if everyone is agreeing that it was 5 o'clock and 14 seconds at one point, in a best case scenario, we are now talking about whether you can make that trip in something like 46 seconds.
And including the numbering.
I would also be, if it would be helpful to the commission, I'd be glad to give my account of what the staff relayed to me in terms of their understanding of the time. I'd be glad to do that as well. Or we can work to get those staff on the call potentially to discuss.
And Chairwoman Jacobs, if I may, I was able to while we're having this discussion, touch base with the staff member who met the representatives from the West campaign at the front door to confirm that one, he was there and opened the door so that there was no interference by the locked door. It did not present any sort of a barrier to entry for the candidates' representatives. He states that the transfer of possession took place at either 5:01 or 5:02. And that does not include the time it took for the page numbering. So you know that the papers were placed on the front desk, but were not fully numbered by that point.
So that I understand, they were physically placed on the desk, but they had not yet been numbered.
That is my understanding from the staff recollection of these events.
And then how long did it take to number them?
I don't have a specific answer to that. My guess being that there's multiple hundreds of pages, it would have taken a little bit of time to do that, but we can see if we have an estimate on that.
Okay, so I can clarify, Mr. Rydecki, because I have minutes and seconds in my brain. 5:01 meaning 5 o'clock plus 1 minute to 5 o'clock plus 2 minutes.
Correct.
Okay, thank you. Commissioner Knudsen, if you're completed with your questions, I'm going to move on to Commissioner Thompson, and then I will go to Commissioner Spindell.
Yep. You can go, Mr. Spindell.
That's fine. No, go ahead.
Go ahead. I'll wait.
Commissioner Spindell, it's your floor.
Okay, thank you. This is for Mr. Kern. Would you agree that the pandemic has made life and everything else much harder?
Yes.
And are you aware that the Democratic National Committee is spending over $20 million in legal fees to change state election laws in multiple states, including Wisconsin, to try and make things easier for the voter?
I was not aware of any amount they're spending.
And that it's the Judge Connolly, who has been able to hear this case, will very soon have his order in terms of what needs to be changed in order to make it easier for the person. So getting along that line, it seems that if on that particular day that all this happened, normally, would you, and I think this is probably correct, would you normally assume that the doors to the building would be open at 4:47 or 5 o'clock if we were not in the middle of a pandemic?
I simply don't have the knowledge as to how that building operates.
Okay. And according to her deposition, she got out of the car, walked to the door. She did not carry the petitions with her because it was her understanding that the door most likely was locked. I went back to her car to make a call to the Election Commission to open the doors. Is that what she stated?
It may be that she made the call when she walked up to the door to get the number, but otherwise I think that's substantially my recollection as well.
Well, if she walked up to the door to get the number, she couldn't make the phone call, could she, until she had the number?
Oh, but I think she may, right. I'm assuming that she made the call while at the door, but I don't know for sure.
Okay, I think she indicated she had to go to the door to find the call, and then she went back to the car. But normally, had the door been open, then most likely she would have been able to take the petitions with her assistant and walk through the door if the door was open, hypothetically.
Yeah, I think that's a fair assumption that that there would not have been the delay that we're discussing now had the door been open.
Are you familiar with the Conlon case?
No, I am not.
Okay, in that particular case, it was ruled that Conlon versus Zimmerman, 1944, which is 76 years ago, it said if the candidate or someone in his behalf had been present in the office of the Secretary of State to tender the nomination papers not later than 5:00 p.m. Central Standard Time, the Secretary of State would have been obliged to accept them. So would that mean that in terms of whether or not the numbers on the pages, whether it's numbered or not, whether it was in physical possession of somebody, is based on that case is really not relevant?
Well, that certainly, I am familiar with the case once you fully stated it. It was part of the briefs in this matter, and I think that also alluded to that staff also referred to that principle that being in the office does meet the requirements. So.
Now, again, in this pandemic situation, normally I believe that the staff would not have somebody downstairs and then somebody holding the elevator and then somebody riding up in the elevator to the election office. And when the door of the elevator opens to the election office, if you've ever been there, there is no other door. That is the election door. So do you think that the fact that once the staff person walked into the building, once she walked into the building with the petitions and so forth and so on, and as I understand, she and her assistant got on the elevator with the staff person, just the three of them, would you not consider that could be transfer of documents at that time? And just to go a little bit further, it appears that Mr. Mendel said that going from walking in the door to the elevator was 27 seconds. So if I add 14 to 27 seconds, that means that when the door of the elevator closed approximately, that was 41 seconds. Does that seem to be appropriate?
I agree that it does.
Okay, so it's very possible that looking at it, that once the door closed to the elevator, even more so than just walking in the door of the building, that the transfer of documents took place. And I think we all agree that whether they were numbered or not is completely irrelevant. And basically the fact that somebody is in there in behalf of the candidate it doesn't mean that they have to physically be transferred along that line. So in a situation like this where it appears that everything is being relaxed, and generally, from GAB and Election Commission rules in the past, we have made, and the predecessors to our Election Commission has made everything as easy as possible for the signers, and also easy as possible to have their signatures count. And in a situation like this, where the pandemic makes things harder, and where everything else there's great efforts in the election process to make everything else different, to spend billions and billions of dollars to try and make the procedure easier for all the voters. Then would you agree that we should try and make it a little bit easier, especially when we put roadblocks up, such as a locked door, and which prohibited somebody from getting in 14 seconds?
I agree.
Okay, and I've trying to do some research, and on your point about is 5 o'clock, or if somebody wants something in is 11:59. I did a lot of time trying to find something, and there's no real definitive action. I did notice that in court cases, as you pointed out, that if they want something in by that particular day, it's 11:59. It has to be in by 11:59. And it would, in that situation, 11:59, so to speak, is still 11:59. And I'm just wondering, do you know, 76 years ago, if there were such things as digital watches and digital iPhones that would give the minutes and seconds?
I don't believe there was.
Okay, and would you think that maybe on the grandfather clocks or something along that line, that as the minute hand moves, that it would be 5 o'clock until such time that the hand hit that 1 minute mark after the 5 o'clock, which would then be 5:01. So that would be basically that it would not hit that 5:01 until 4:59, or I'm sorry, it would not hit that 5:01 until it was 5:59 point whatever.
I also agree.
And this case also is 76 years old, which is a long time along that. And I would suspect that the 5 o'clock would possibly go to 5:59. But let's take the rounding situation in terms of somebody walking in the building. Generally, when we round off numbers, if something gets to the 30, isn't that normally moved up to the next level? So if it's 5, 4, 5, and 30, it could be considered to be 5:01, or if it's 5:24, it could be it was generally put back to the other area. I mean, that's just simply math in around rounding type areas. So the other question is in a situation like this, and we know it was brought by the Democratic Party. My question is, when do you think the Democratic Party is going to stop trying to suppress the black vote?
I'm going to ask you to pause for a moment. We have lost Commissioner Thompson.
Okay.
And I'm going to ask you to pause for a minute.
It's, on our screen, it's a little bit hard because we don't have Dean on my screen. And we do have and we need the 2 attorneys, Megan, and the 6 commissioners. And I'm wondering if the gentleman who was monitoring this could maybe make sure that all of us are on the same screen. Are you seeing the same thing I am?
Bob, you need to set your settings under video to only see the people who have video. If you go down.
Yeah, but there's more than 6. I can only have 9 on mine.
That's a setting that you control, not the moderator.
Okay.
I instructed Commissioner Thompson to log back in.
Okay. So we're all set?
Nope, he's not in yet.
Okay. Oh, he's not in yet. Okay.
Jacob, can you please go to participants and invite Commissioner Thompson?
Yes, I had just sent an invite a moment ago.
Did you send it to his work email instead of his state one?
I did not. I can send one to his work email right now. I'll just need that provided. I have a Hotmail email that I will send it to.
I'll send it.
Bob, is your screen showing non-video participants?
Well, now it is.
Like
Sherry,
for example,
Sherry is showing up. Let me take a look at the next screen.
Go in the upper right. Corner.
I have you on there and Megan now, and on the other one, who do we pick up?
Go in the upper right corner, for example, of Sherry's.
Yeah.
And then there's a little blue box, ... When you do those settings, it'll give you the choice to just not show them. And then more video participants will and at least move them off your screen. Some of the staff members that are just on audio listening.
Back on. All right.
Okay. Well, I don't want to try and,
My apologies.
I better not try and screw it up.
Okay.
Otherwise we may have another.
All right,
Wait.
we are back on the record. Commissioner Thompson has reappeared. Commissioner Spindell, you can continue where you were.
Is it your understanding that the Democratic Party, the media reports say that they do not wish to have Mr. West on the ballot because they're afraid that blacks may vote for him as opposed to Mr. Biden?
I would assume that there are different reasons, but I believe that that is likely one of them.
Yeah, I think that's actually a media report. And then that sort of brings me to the point in terms of the Wisconsin Democrats, which is the people that are bringing this challenge. My question is, when are they going to stop suppressing the black vote? We had the problem in Milwaukee with 180 units being brought down to 5, which definitely affected the black vote. Here, they wish to take away from the black population an opportunity to take a black presidential candidate off the ballot and have a choice in terms of who they want to vote for. And we're, the same thing with the Green Party, where we have a black activist who's running for vice president that they want to get off. And, what's next in terms of trying to suppress the black choice? I mean, the Republicans had an opportunity to try and to do something with the libertarians, which they did not, and they welcome them. And we got to recognize, that there's some people that may not want to vote for Trump or want to vote for Biden. So I think this situation is something that I would hope that the Democratic Party will try and take a look at and try, in my opinion, their suppression of the black vote. And that's all the questions I have at this point.
Okay, Commissioner Thompson.
Oh, no.
Oh,
there we go.
I was interested, this is for Mr. Kern before I get to Mr. Mendel, but Mr. Kern, you had said that if someone had been missing red lights or left late and got stuck at a train stop or something, the candidate would have another remedy. What would that remedy be?
I think it would be a petition to court, perhaps a seeking a writ of cert for extraordinary circumstances causing the inability to meet a deadline. And I'm not exactly sure of the mechanism, but it seems to me that there would be a path to try to convince a court that the campaign should otherwise be accepted.
But I mean, generally, you would accept the premise that if it's 5:02, you didn't make the time, right?
I would, yes.
Okay. See, and this I'm going to sort of address this to Mr. Knutsen's question about whether we need the staff on to tell us how late the transfer took place. I see, to me, and this is also to Mr. Spindell, I don't think this is a hyper technical kind of question. I think this has to do with discussions that we've had previously on what is the common sense approach to accepting papers to put candidates on the ballot. And there was a consensus that if you're late, you're late. And that's just the way it is. I watched this video several times. It was clear that the two folks in the car sat in the car for probably over 3 minutes when they could have walked in, because we know that there was someone at the door, and when they got to the door opened immediately. There wasn't an issue, and they didn't get out of the car until 5 o'clock. And the way I'm looking at it, it's sort of like, and this is addressed what Mr. Kern he said that he thinks that there's a drafting error, and the whole scenario got tested up to go to the courts to find out whether there's a drafting error. I mean, I'm looking at this. Why did they sit there for 3 minutes and wait till 5 before they went in? We all know, it's undisputed, that no one made it in the building until after 5. And Mr. Knudsen asked questions about what time. We just don't know how late that is. We know that it's after 5. We just don't know how late after 5. And I just watched it. We're sitting here arguing, setting up, because it's going to the courts to argue whether or not there's a drafting error. Because this, I do not think it has anything to do with, and what I think the big picture for the commission is, are we going to take the common sense approach and say, look, you're late. There isn't a reason to change it. This wasn't, everyone knew, Bob brought up COVID-19, everyone knew. And here's sort of a question that I have to both Mr. Mendel and Mr. Curran. How many of the signatures that have been gone through were gathered by the campaign on the days before they were turned in after 5 and late? Did anybody do that calculation?
I did not.
Yes, Mr. Commissioner. Every single signature that was submitted was gathered on August 3rd or August 4th, and the deadline was the 4th. There is not a single signature that was submitted to the commission that I am aware of that is dated prior to Monday, August 3rd.
So they got all the signatures in 2 days. They had them. They got there, and then they sat in the car and waited till 5 o'clock to walk in the building. To me, this is a practical question, and I don't have any more questions. But I think what we really have to vote on is: are we going to say for a candidate, if you're late, you're late? And the consensus was, when you're late, you're late. We can get more testimony to find out, Dean, how late they were, but we all know the papers didn't get into the building until after 5. They weren't close to the office, and they weren't close to being transferred. And this is not a question of seconds or this construction. It's after 5, and that is where we have historically taken the position. And anyway, that's all I have. Thank you.
Thank you, Commissioner Thompson. Commissioner Glancy or Bostelman, who would like to speak next? Commissioner Glancy.
I just have, I think, 2 more comments than questions. Is when you talk about the filing officer, the person who accepted the paper shouldn't have done it. We also have them accept papers that we as a commission later on determine are insufficient. It is not, as Megan had pointed out, that person at the counter who's accepting things to make those decisions. So I don't really feel it was an error on their part to accept the papers when they were handed to them. They maybe should have locked the door at 5 o'clock, but the papers were handed to them, and it wasn't their position or in their power to say, I'm just not going to take them. That would have been an entire other lawsuit. So, I really don't agree with that. The second, I guess, point I want to make is we determine whether people have ballot status or not. And I have a great deal of empathy for anybody who files nomination papers, because I've been through that. I know how difficult it can be and how challenging it sometimes can be. But they are required to have this many signatures and filed at this time. And we have taken people away from having ballot status because they were 1 signature short. So if we're going to hold their feet to the fire on the number of signatures, I think we also have to hold their feet to the fire on the time it needs to be filed. So that, I guess, is my only statement.
Thank you, Commissioner Glancy. Commissioner Bostelman.
I'm kind of on the same wave as Commissioner Glancy. When she and I both were filing officers for our counties, so papers needed to come in on time. And I think the thing that I worry about most is setting precedent. If we need to determine whether something is late or not late, and we can't. I think we need to go with the record in previously, and you all can help me with this because I'm newer and I've never gone through this on the commission, but I'm assuming that prior to this, papers had to be received by 5 o'clock. And if it was not 5:01. So we need to determine now what type of precedent are we going to establish going forward. And I think we follow the past. If it's after 5 o'clock, it's considered late. I feel very strongly about that. I have received papers that were late and were not accepted, and I've received papers that were right on the minute before and yet didn't have enough signatures. So I believe that it's a personal responsibility to make sure that when an individual is submitting papers, nomination papers, that they know that they have enough signatures and they know that they are on time. So and if you can, I guess if it has been 5 o'clock in the past, I don't know how you now decide that what was true in the statute before today is different as of today. And there are many legal attorneys on this Zoom meeting, and if you can explain that to me, I'd be happy to hear that.
Thank you, Commissioner Bostelman. Commissioner Knudsen, we do have the staff members available. This is sort of unusual circumstances. Commissioner Thompson has indicated that it's after 5, regardless of how far after. Commissioner Spindell is of the opinion that there's some fluidity there. Given the unique circumstances, if you feel that you wish to have their testimony, they are available. And as chair, I would allow that. I don't know that I think it's necessary. The staff has told us what time they arrived, but if you wish for that, they are available and we can bring them into the meeting.
Well, all I'm looking for is on page 15 of the staff memo at the top of the first paragraph, number 4, paragraph or item number 4. It states, the papers were not in the possession of the commission by 5:01. And all I'm saying is, I don't know if it's appropriate or not in this hearing for us to hear from our staff. This goes back to what I was getting at earlier when I said there's 2 decisions and there's 2 things on the agenda. One starts at page 34 of the memo, and it's for the commission decide on our own whether there were sufficient signatures timely filed. And then there's our decision on the complaint that was filed, and they cover the same material. I don't really care procedurally. I mean, here we are. But I think the crux of both of those is encompassed in that fact. If we're to take this staff memo as fact, do we need to have somebody read it into the record so that we're ready for on potential appeal that this is what we based it on? And that's basically what I'm saying. It's my desire, but I'm posing it to you guys, to the staff and Nathan as a question. Do we take this as sworn testimony, this staff memo, or do we need to have a staff member come before us and swear to us that they were not in the possession of the commission by 5:01? That's my question, Nate. And I mean, to me, this all kind of hinges on that. That's what it's all about here.
Sure.
And you see where I'm going?
I do.
Can you help me out?
Yeah, I think so. My response to that would be, when these types of cases have gone to court, the staff recommendation memo is always part of the record that goes to the judge under 227 type administrative review. So it's the complaint, it's the response, the any of the exhibits that were part, the staff recommendations, the memo, any of the motions, all that goes is part of the record. So that does go to the judge for them to to review, and then they weigh and determine what was the commission proper in making their determination based on what the recommendations were and what the evidence was provided to them. So as far as the statement, the nomination papers were not in the possession of the filing officer by 501. That was stated because of the conversations that we had with the staff. The 5 o'clock -14 was not when they filed or took possession of it. It was at the door.
Nate, if you'll hold on for a moment, we lost Commissioner Thompson again.
Okay.
I will send an invite to him again. We get Commissioner Thompson? Commissioner Thompson is rebooting. So hopefully he'll be on very shortly. And Commissioner Thompson is back. All right.
Okay, so here's what I'm trying to get at is that statement at the top of page 15, the papers were not in the possession at 501. By what means was that determined? Who determined it? On what, what is that statement based on? What did somebody look at their own watch upstairs? Have we tried to, is there security camera video or some other means within the building for us to know what was going on and at what time? What steps have we taken to verify that that statement is actual, true and factual?
It is based on conversations with Riley, who was the individual that was at the elevator when the individuals came off the elevator. That's based on the fact that
I'm going to pause you there. I think the answer to this is both of these gentlemen are available. And in the interest of creating a complete record, my intention would be to bring them in front of the commission to briefly be sworn and enter testimony. The commissioners may ask any questions of them they wish. I'm not going to have, I don't think the parties specifically question them unless there's some particular reason to do that, because I think it's going to be, this is not really a trial, but I think Commissioner Knudsen's questions of exactly the factual basis, they're available to us. I think if we were live, we would bring them in. So we will bring them in. Administrator Wolf or Mr. Rydecki, is one of you able to bring them into our meeting, please?
Yes, we are. We've added them as panelists and they will be joining us shortly.
Thank you.
And Madam Chair, forgive me if this is out of order, but can I make a point, please?
Briefly.
Yes, pursuant to 2.05 of the Election Code, extrinsic evidence is appropriate when challenging the facial sufficiency of a complaint. But we're talking about the timeliness pursuant to parent 2 of that statute. And I just don't know that extrinsic evidence is appropriate under these circumstances. And so to the extent I can object, I will, but I understand that that may not matter.
Well, let me ask you this. Are you conceding that the papers were not in the hands of the filing officer at exactly 5 p.m.?
No, not at all.
Okay. Then who was at the door? Was that Riley?
Cody Davies was the election specialist who was downstairs at the front door, and Riley Willman was the one that was on the 3rd floor waiting to receive upon them getting off the elevator.
And is Cody Davies available to be on video?
Yes, he is.
He is. Okay. We're going to begin with Cody because he was at the front door. Cody, would you please raise your right hand? You solemnly swear or affirm that the testimony you are about to give is the truth and the whole truth and nothing but the truth?
I do.
What is your complete name?
Cody Christopher Davies.
How are you employed?
I'm an elections administration specialist for the Wisconsin Elections Commission.
Thank you, Mr. Davies. You can put your hand down. We are here discussing the filing of the nomination papers of Kanye West, which occurred on, let's see now, August 4th, 2020. You are aware of that?
I am.
And at August 4th, 2020, at approximately 4:55 p.m., where were you?
I was downstairs at the lobby at 212 East Washington waiting for anyone who might try to file nomination papers prior to the 5 o'clock deadline.
And what were your instructions?
My instructions were to watch the front door and make sure anyone who would try to file papers was able to enter the building and to escort them upstairs if they did.
Right. And what did you observe that afternoon at between 4:55 and 5 p.m.?
There were a number of folks outside with cameras. I can't stipulate how many of them were out there. I saw at least 3 folks. 4:55 is when I went downstairs. At 4:57, I was also the individual who took the phone call from the campaign staff indicating that they were approximately 3 minutes away. I remember saying something to the effect of 3 minutes is bad, 2 minutes is better, as it was 4:57 at the time. And as soon as I saw them coming up the stairs, I went to go open the inner door. They had opened the outer door themselves. 14 seconds or so after 5 p.m. is my best recollection as to when that happened. I had been observing the clock icon on the face of my phone. I remember the little red second hand clearly passing 5 p.m. and after 12 to 14 seconds, they reached the stairs in front of the building and I went to go open the door. I escorted them upstairs.
I'm going to pause you for just a moment, Mr. Davies. Did you inform them at that time that they were 14 seconds over?
I do not recall if it came up at that time. There was a discussion when we got upstairs that I needed to consult with management and with staff counsel as they had filed effectively after 5 p.m. and I was uncertain at that time of how to best proceed.
Okay, So when you open the door between 5:12 and 5:14 p.m., 5 o'clock and 12 seconds or 5 o'clock and 14 seconds after 5 p.m., where did you then go? Please trace your route for us.
Of course. So the two members from the West campaign and then two other folks followed them in the door. I believe they were representatives of the media. We then proceeded to the main elevator in the building here, at which point the two representatives from the campaign and myself entered the elevator. The two representatives of the media asked if they could come along. I didn't feel as though that was appropriate. It was after hours, and social distancing being what it was, I think we're already a little packed into the elevator. Then we had to scan in, so the access to the third floor is restricted to members of the Wisconsin Elections Commission. So I had to scan my ID badge. The doors closed, and then we went upstairs. After that, as was mentioned earlier, the doors open, you are immediately in the office. At that time, I would say,
I'm going to ask you to
yes,
pause there for a moment, please.
of course.
At any time prior to the moment when the doors of the elevator opened into the offices of the Election Commission, had you taken possession of any of the petitions?
I did not. We did not touch the papers until after they had been put on the counter at the front desk.
Okay. Were you present when those papers were placed on the counter of the front desk?
I was.
And to the best of your recollection, at what time were they placed on the counter of the front desk?
I cannot say for certain. I know I did glance at my watch while in the elevator, but I cannot give a specific time as to when that would have been.
Are you able to tell us what time it was when you glanced at your watch in the elevator?
It was about 10 seconds before 5:01. I cannot speak to the accuracy of my watch, however.
Okay. When the documents were placed on the counter, did you have any further interaction with the persons filing them?
It was at that point where I told them I was going to go back to my desk to try to reach management and Nate to discuss how to best proceed, because there was a question of timeliness. One of the representatives at that point informed me that the statute said 5 p.m., not 5:00:00. And I said, okay, and I do need to confirm that with staff counsel. And then I went back to my desk immediately. After that, intermittent, because we were going back and forth trying to, process the papers and get a hold of someone else with legal expertise at that time. So between Riley and myself, we did interact with them for probably the next half an hour intermittently.
Do you have any reason to believe your wristwatch is inaccurate?
Not, outside normal inaccuracy from a wristwatch. It costs $25 on Amazon, so it's not an atomic clock by any sense, but it's fairly accurate, I would say.
Okay. Have you had any problems with it losing time or otherwise being inaccurate?
The greatest inaccuracy I've found so far is that it is set on a 30-day calendar month, so it gets a little problematic around leap years, but other than that, no.
Okay. All right, so those are my basic outlines of the questions for Mr. Davies. If the commissioners have any specific questions on topic, which is as to his knowledge, they may ask them. Commissioner Knudsen, do you have any additional questions for Mr. Davies? Commissioner Thompson.
As I said, it's not for us to determine how late the papers were. We have unequivocal testimony that it got into the building after 5 o'clock. So I have no questions because I don't think it's relevant to any issue.
Commissioner Spindell, as to Mr. Davies' specific factual testimony and limited only to that.
Yes,
yes,
I will. You indicated that you were in the lobby at 4:55. Were you off the elevator and in the lobby at 4:55?
I was, yes.
Okay. And around 4:57, did you see anybody approach the door to the building and then walk away from the building?
I did not. Just the individuals who were congregated outside of the building prior to me arriving downstairs. Neither of the representatives who ultimately came upstairs with me were down there.
Okay, and then you indicated that you received a call from at 4:57, and who was that from?
It was from someone identifying themselves as a member of the West campaign, saying that they were on their way to drop off the papers.
Now, when they said we're on our way to drop off the papers, did you think that that meant they were, I think you indicated 3 minutes away. Did you think they were driving, or did you know that they were outside?
I was not aware they were outside. To my knowledge, it sounded like they were still driving. They had indicated that there were people in front of the building and that there were people on the corners of the sidewalk. So some of the commentary was not the clearest. So yeah, like I said, it sounded as though they were still driving toward the building at that point.
Okay, and then at some time before 5 o'clock or whenever that might be, did you see the car out in front of the staircase, I guess, to the building?
I did not.
Okay, so the first time you saw somebody that resembled this particular group coming in was as they started to walk up the stairs and towards the front door?
Correct.
Okay, when you saw that, did you, how far were you from the door when you saw that? Were you right at the door?
I would say I was about 3 feet from the door. As soon as I saw someone approach the bottom step, I went to go open the inner of the two doors at that time.
Okay, and then they basically didn't have to wait for you to open the door. The door was open and they could walk right in. Is that correct?
The outer door, as soon as they opened that, the inner door was already open and they proceeded immediately in.
So they had to open an outer door, which I guess is like a storm door or something like that, and then there's an inner door. Is that the way that's set up?
Correct. There are two glass doors down there. They're both roughly of the same design with a little antechamber in between them. The outside door, they opened themselves. It was not locked. I opened the inner door at the same time, so they didn't have to wait in either case.
Okay. And on before the pandemic, at previous times such as these, was it the practice of the Election Commission to have somebody downstairs to point people to the elevator so they could get up upstairs?
To my recollection, prior to the pandemic, the building manager would keep the doors unlocked. There would be signage that would indicate where we were, where the filing officer's desk was. The elevator did not used to be restricted access to the third floor either. So no, I do not believe that in previous filing deadlines there was someone downstairs. But
okay, and then you got in the elevator, and I think Mr. Mandel indicated that it took 27 seconds. That they came in about 5:14. They got through the door. 27 seconds to get in the elevator. And when you looked at your watch at 5:50, were the doors to the elevator closed?
They were still closed. We hadn't reached the third floor yet. Okay,
so you were in the process of at 5 o'clock and 50 seconds. You were somehow going up in the elevator. Do you know approximately how much? I've been in several times. I know it's awfully slow elevator. Do you know how long it generally takes to get from the first floor to the third floor in the elevator?
Not offhand. I suppose I've never thought about it.
Yeah, I don't think we did. And then so basically to recoup, it came in about 14 seconds after 5 o'clock. You were in the elevator at 5:50, and as you indicated, that when the door opens to the elevator, that in effect is the door to the Election Commission. Is that correct? There's no other door that somebody has to go through.
Correct. You're immediately at the front desk.
Okay, and given the where you were, in terms of when you looked at your watch, do you have any idea approximately what percentage of the ride from the first floor to the third floor that you had taken when you looked at your watch? Was it a third, 2/3, half? Any thought on that?
I can't speak to that. I know there was still some time, and as you've ridden in the elevator yourself, you know that after the elevator reaches the third floor, there is a momentary pause before the doors open. I can't exactly tell you how much of the ride had.
Okay, and have you been in the office at times when, not during this time, but during your career at the Wisconsin Election Commission on filing days?
I have.
Okay. And generally, what takes place? I know in the last one that we had the filing at a different location, but what is the normal procedure at 5 o'clock? If there's a line of people that get in there by 5 o'clock, so to speak, chances are, if there's more than one or two people in line at 5 o'clock, that the people in line other than the first one is not going to be able to transfer their papers to the clerk at the desk. Is that correct?
Honestly, I can't speak to that. In most filing deadlines, in my experience, there has been a member of the front desk staff there processing intake and doing that portion of the process. I would typically be at my desk at that time waiting to be called up to review papers or speak with the candidate. So I cannot speak to normal procedures at 5 p.m.
Okay. Have you ever seen at 5 o'clock on some of these election, the days that the filings are due or the petitions are due, when there's more than one candidate filing at 5 o'clock in the airport?
Commissioner Spindell, I did ask that we limit our questions.
Okay, that's fine.
To Mr.
That's fine.
Whitman.
All right. Well, thank you very much.
Observations of the day of filing.
That's fine. That's fine.
General procedure are best directed to Administrator Wolf or Mr. Rydecki.
Okay. Well, thank you very much. Appreciate it.
Okay.
Thank you.
Do any other commissioners have any questions for Mr. Davies? Hearing none. Thank you, Mr. Davies. You are released. I'm going to ask Mr. Willman now. Mr. Willman, are you able to unmute?
Yes, I should be unmuted.
Yes, you are. All right. Thank you. If you would please raise your right hand. Do you solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth?
I do.
What is your complete name, please?
My full name is Riley Peter Willman.
How are you employed?
I'm an election administration specialist at the Wisconsin Elections Commission.
How long have you had that position?
About 2.5 years.
We are here discussing, you may put your hand down, sir. We are here discussing the events of August 4th with regards to the filing of the Kanye West nominating papers. Were you involved in that process?
Yes, I was in the office on that day.
Can you please describe for us what you saw as to the arrival of those papers?
Yes, so my colleague Cody Davies did go down to the lobby shortly before 5 to watch the front door to see if anyone would come in while it was locked. I was at my desk as we had another candidate who had come to the office around 4:30 who was being processed by another specialist who did need her documents notarized. So at 5 o'clock, I noticed on an agency cell phone that is tied to an alternate number used for the front doors I noticed that it was 5, went up to the lobby where then I saw the representatives from the West campaign and Cody Davies were there and then started talking with Cody about the time of the filing.
And when you say they were there, were they already stationed in the lobby? Were they coming off the elevator?
They were in the lobby.
Okay. Where were the papers?
They were still in the hands of the West representatives.
Okay. And what happened to those papers?
They put them on the counter and then started going through and organizing them. They had to number pages. They had to organize them. Both representatives had stacks of their own.
Did they tender them to you for filing at that time?
At that time, they were simply on the counter. They were going through and organizing them. We did not begin the normal check-in process until a couple minutes later after we had been able to reach Nate and some management members to discuss what next to do.
And did you personally speak with Nate or management members?
I did not speak with them, no.
Okay. While they were organizing the papers, had anyone handed them to you?
No, we did not touch those papers until after we had talked to management and council. At what time, to the best of your recollection,
did those papers land on the desk?
To the best of my recollection, it was at 5:01.
Okay. And at what time, to the best of your recollection, were the papers organized and numbered as required?
It would have been several minutes after 5:01. I'm not sure the exact time, but they did take a couple minutes to organize the papers themselves.
Okay. Do any of the commissioners have additional questions as to Mr. Willman's specific factual recollections of the filing of the West papers?
Yeah, I just have one question.
Okay.
When you took a look at your, what did you do? Take a look at your watch, clock? Where did you see the 5:01? What sort of timepiece was that?
That would have been my watch.
Okay. And when you looked at your watch, what had been accomplished by that time?
They were just in the front of our office. So I don't know if they had just stopped off the elevator, but I kind of turned around the corner and noticed that they were in our office.
Okay. And do you know if it was closer to 5:02 or 5 o'clock? You probably don't have an idea on that, do you?
I'm not sure of that, no.
Okay. That's all I have. Thank you.
Any other commissioners have any questions for Mr. Willman? Okay, thank you, Mr. Willman. Oh, Commissioner Knudsen.
Sorry, I'm slow on the unmute. Riley, my original question before you joined the meeting here was, at what time did the Elections Commission staff take physical possession of the papers?
It would have been several minutes after 5 as they were organizing them. We wanted to check with staff of what to do next. As long as I have worked at the commission, we have not had someone file so close to the 5 p.m. deadline. So I was not aware of how to proceed going forward. So as far as I can speak for myself, I did not touch those papers until several minutes after 5 when we began the normal front desk check-in process.
Okay, thank you.
Just to clarify, following up on Commissioner Knudsen's question, was there a delay between when they were done organizing the papers and your receipt of information from higher ups to accept them?
I was not aware. I was not at the front desk. There was a time period where they were at the front desk where we were still waiting to hear from management. So I was not up there at that time.
Okay. All right. Anyone have any other questions? Okay. Thank you, Mr. Willman. You are excused. All right. All right. Do commissioners have any other questions for, I think we were sort of, well, I guess technically I will ask, do the commissioners have any questions for Mr. Curran or Mr. Mandel at this time?
I just have one for Mr. Mandel.
Okay, go ahead.
Okay. Mr. Mandel, obviously you're familiar with Colin versus Zimmerman. And are you familiar with the fact that the case states if the candidate or someone in his behalf have been present in the office of the Secretary of State to tender the nomination papers not later than 5 o'clock p.m. Central Standard Time, the Secretary of State would have been obliged to accept them?
Commissioner Spindell, I am aware that that the case says that. I would suggest to the commission, however, that that is not a constitutional rule. That is the court's explanation of what the rules and statutes were at the time. And now we have Wisconsin Administrative Code, Chapter EL 2.05, Subdivision 2, which is much clearer. And it says, quote, in order to be timely filed, all nomination papers shall be in the physical possession of the filing officer by the statutory deadline, period. Each of the nomination papers shall be numbered before they are filed, and the numbers shall be assigned sequentially, beginning with the number 1, period. So, you know, I think that respectfully, I would suggest that the Wisconsin Administrative Code, which is the law of the land, trumps the interpretation of the Supreme Court of the rules that were in place at that time.
Mr. Kern, do you have any response on that?
I'm not familiar with what the law was on the books at the time the Supreme Court decision was made, but certainly the Supreme Court decision makes more sense when you take everything in its totality.
Okay, thank you.
All right. Do any other commissioners have any questions for the attorneys? Do any of the commissioners have any questions for Attorney Judnick before we go to discuss whether or not there are motions before the commission? All right. I will now, there are suggested motions, and for those who are watching this hearing remotely, those are suggested motions that are made by the staff, and the commission is allowed to make those motions, make other motions, and the like.
If I may, Madam Chair.
Yes, Commissioner Thompson.
I believe that the applicable motions on this, if I'm right, are at page 28 and 29. Am I correct?
You are. I was just paging through my materials to find those pages. Thank you.
Recommended motions 1 through 8. I would move and make the motion, or make those motions.
Commissioner Thompson moves recommended motions 1 through 8 on pages 28 and 29. I'm going to allow the commissioners to turn to those pages and review them.
We also have a visual if the chair would like us to bring them up on the screen.
I think that would be terrific. There is the summary of the challenges. Okay, and do we have the suggested motions, please, Jacob? All right. And the next slide, please, with the remaining motions. And the next slide, because there's still more. All right. We have a motion to adopt or a motion on the floor. Is there a second from a commissioner?
I'll second.
I'd like to make a friendly amendment.
Well, hold on.
Okay.
Commissioner Glancy has seconded the motion. All right. Commissioner Spindell wishes to seek leave to have a friendly amendment.
Yes, my friendly amendment is that we consider 2, 3, 4, 5, 6, 7, 8, and then come back for the motion on number 1.
Commissioner Thompson, what is your decision?
Unfortunately, I didn't hear his comment.
Okay, I'm sorry. My amendment would be that the commission consider for this motion 2, 3, 4, 5, 6, 7, 8, and then in a separate motion, we would come back to number 1 for discussion.
Commissioner Glancy?
I think we need to take number 8 with number 1 if we're going to divide the question, because number 8 refers to submitting the findings, and we won't have done that until we've done number 1.
That's fine.
Look, I don't have a problem breaking it down if Mr. Spindell wants to take 2 votes.
Okay, Commissioner Thompson, it's your motion. Which ones do you want to do first?
My friendly amendment was that we do 2, 3, 4, 5, 6, 7 first.
But you didn't make the motion, so Mr. Thompson sort of gets to decide on that one.
I know, I understand. Yeah, that
No,
was
no,
the friendly amendment.
We'll make that the first motion. Yeah.
Okay, so the motion on the floor is to adopt recommended motions 2, 3, 4, 5, 6, and 7. Commissioner Glancy, do you again second that motion?
Yes.
Okay, is there discussion on those recommended motions? Hearing none, I'll call the vote. Commissioner Bostelman,
Aye.
Commissioner Glancy,
Aye.
Commissioner Christensen,
Aye.
Commissioner Sindell,
Aye.
Commissioner Thompson,
Aye.
Jacobs votes aye. Those are passed unanimously. Commissioner Thompson, are you moving number 1 now?
Number 1 and number 8.
Number 1 and number 8. Commissioner Clancy, are you seconding 1 and 8?
Yes.
Okay, we have motions as to number 1 and number 8. Is there discussion on those motions?
Yes, I'd like to say something if I could.
You may.
Okay. I think this is a very interesting situation. And I think had the pandemic not been around like many things, the people here would have been able to get to the upstairs at the appropriate time. I think there's probably, you know, in terms of whether it should be 5 o'clock or whether it should be 5:00:59 or whatever it is. I think it's pretty clear that in terms of the time frame, that the person was pretty close to the office by 5:00:59. As a matter of fact, the gentleman said that he looked at his watch somewhere on his way up to the office, where the door of the office again is the elevator, and it opened. Whether it's my contention basically that the time of possession should be when the person representing the West campaign walked in the door at 5:14. Given that there was some more time involved in that, and somewhere at 5:50, 10 seconds before the magic number, so to speak, they were somewhere in the elevator. We're not quite sure in terms of what time the elevator opened. Did it open at 5:00:59? Did it open at 5:01:001? I think that's a question that is out there. But I think that we need to put Mr. West on the ballot here. I do not think it's right that we go against, maybe it's not 2,000 seniors, maybe it's 1,800 or whatever. If there's 100 that said they didn't do it, of course, we don't really know that. But 2,000 people indicated that Mr. West should be put in the ballot. Mr. West is an African-American candidate, and I think we should do all we can to, after the terrible treatment that the Black population in Milwaukee received during the April election, that we give them a choice. I don't think it's up to us to say you cannot have a choice in terms of which candidate you would like to vote for. So basically, I think it was close, but I think that it was handled before 5:00:59. And I think all indications, and I spent a lot of time trying to find something definitive on this, but I did see 11, for court records, 11:59. It has to be in by that time. It should have said 11:59, 4:59, but maybe 76 years ago, they weren't paying attention to the seconds as we are now. So it's my belief that we should reject number 1.
Would any other commissioners like to speak? Commissioner Knudsen, you waved your hand.
Well, this is one of the closest call cases that I've seen, but consistency requires me to treat all candidates the same, regardless of their party, regardless of their color or any other characteristic of the candidate. Sometimes I've said our job is to call balls and strikes. This time it feels more like we're a line judge determining if somebody stepped out of bounds or crossed the goal line, and it is a close call. I think the complaint has the burden of reaching clear evidence, clear factual evidence that it wasn't timely. And I think they meet that burden. So to me, while I regret that, it's the case, I do not feel like they filed timely. And so I'll support the motion.
Thank you, Commissioner Knudsen. Commissioner Bostelman.
I go back to what I said before, that I think we need to be careful of whatever type of precedent we set here. And I believe that it was not timely. And I agree that I feel bad that it's not, but I also believe that other candidates were able to get filings in on time. And I think that that's regretful that they didn't get it in on time, but I think we need to stick with, we shouldn't set a new precedent based on how things have been voted for in the past. And it seems to me that I've been told that if they were late, they were late. And I guess I also support the motion.
Thank you, Commissioner Bostelman. Do any other commissioners wish to be heard?
I just have one more comment. I don't think they were late. I think they met the requirements by before 50059, and therefore I do not think they were late. I guess in future times we're going to have a. I don't think the decision has still been made in terms of whether 5 o'clock is 5000000 or 5 o'clock is 5000001. I guess we'll need some sort of time clock up there that's based in a direct line to the tower in London or whatever it is that has a world's time to make sure that we're exactly right. I mean, we are talking a matter of seconds here, and I don't think that the all the information that we have gotten does, even though that the door to the office, which is the elevator door to the office, which is the door to the election commission, that they weren't there by 50059. And so the question in terms of is it 5000000 or is it 50059? Which one is the correct time? I know I used to own a bunch of restaurants, and if somebody showed up at 10 o'clock at night, they could get in. If somebody showed up at 10:0001, the help could have closed the store. So it's my belief that yes, she was on time, and two, that the transfer took place as soon as our staff member met that person in the lobby and went up in the lobby with her, because in the past there has not been anybody in the lobby to do this because of this very unusual situation. Thank you.
Thank you.
That's all I have.
Are there any other commissioners who wish to speak on this?
I call the question.
Commissioner Thompson calls the question. We will take a vote. The motion is recommended motion number 1, that the commission sustains the challenge to all nomination papers submitted by Mr. West and Ms. Tidball because they were not filed timely in accordance with Wisconsin statute 8.20 sub 8 sub AM. Therefore, their names shall not appear on the 2020 November general election ballot as independent candidates for president and vice president, respectively, in Wisconsin. Commissioner Bostelman, what do you vote?
I vote. Did you hear me? Aye.
Commissioner Bostelman votes aye. Commissioner Glancy?
Aye.
Commissioner Glancy votes aye. Commissioner Knudsen?
Aye.
Commissioner Knudsen votes aye. Commissioner Spindell?
No.
Commissioner Spindell votes no. Commissioner Thompson?
Aye.
Commissioner Thompson votes aye. I vote aye. The motion is carried 5-1. We have been at this for 2.5 hours. Would the commissioners like a brief break before we take the next challenge?
Sure, that'd be nice.
Thompson's waving his hand. Is that a yes, Commissioner Thompson?
That's 5 minutes.
5 minutes. All right, we will take a 5-minute break. And please make it exactly 5 minutes because we got a long way to go.
It's 5:33. Do we want to make it just, what, 5:40? Make it so we have a time, definite time?
5:40 at the request of Commissioner Spindell. Please be back.
Okay. Thank you.
And so I thought maybe that's a way to, yeah, I know. All right, do you need anything?
Maybe small water. Yeah. Thank you.
Hey, Reed, you're not muted.
Before we go back on, Jacob, do we have Mr. Santeller?
I was told that we do.
Mr. Santeller is on by phone. He indicated he was having connectivity issues and not able to appear by Zoom.
Okay, thank you. Commissioner Bostelman, are you back? There we go. 1, 2, 3, 4. There we go. 1, 2.
I believe we have all commissioners and staff that we're expecting.
Yes, it does appear so. We will reconvene the meeting of the Wisconsin Election Commission. We do have a challenge by Joseph Santeller, who will be appearing by phone. As with the previous format, we will allow Mr. Santeller to present for up to 10 minutes. We will then allow Attorney Curran to present for up to 10 minutes, and then the commission will be able to ask them questions, ask questions of staff counsel, and then entertain any motions. Mr. Santeller, are you on the line?
I am on the line.
All right, you may proceed. You have up to 10 minutes to discuss with the Elections Commission.
Thank you, and good afternoon. I'd like to thank members of the commission as well as commission staff for all of your time in waiting for me to get connected and hearing the complaint today, and for taking the time to review this. So thank you for that. I'd like to start with a similar point of order that was raised by Attorney Mandel by noting that the response to my complaint was not verified by the candidate I challenged. Now, this point is different in my case because I didn't name vice presidential candidate Tidball in my complaint. So the only candidate challenged in my complaint is Mr. West. And that candidate did not verify the response. So in my view, the allegations in my complaint stand unrebutted due to the candidate challenge failure to verify his response in accordance with section EL 2.07 sub 2 pair B. So that is an initial point of order I'd like to make.
Okay. Does the commission wish to discuss the point of order, or is there a motion on the point of order?
Does anyone have the page number of the response to this in the 1,600 pages?
Yes, I pulled it.
Madam Chair, if I may, it's Jeff Mandel. The verification is on page 948 of the commission materials.
Thank you, Attorney Mandel. That's very helpful. Okay, Commissioner Knudsen, does that answer your question, or are you looking at it online?
I'm looking at it, or trying to.
And Madam Chair, just in case I misunderstood Commissioner Knudsen's question, the response itself begins on page 872 of the commission materials.
Okay.
As we discussed, it was a joint response, so a response to both. So the same response that was filed in the Brent matter is the same response for this matter.
Oh, I see. Okay. Okay, that's my only question.
So the point of order was that Mr. Santeller's challenge was directed only to candidate West and not to candidate Tidball, and therefore excuse me, and therefore it is lacking verification. Is there a motion from any commissioner regarding this point of order?
Swindell. I make a motion that we disregard this point of order and continue on with our hearing.
Okay, there's a motion. Is there a second? Commissioner Knudsen seconds. Is there further discussion on this? Are you seconding, Commissioner Knudsen? Yes, okay. Is there any further discussion on this point of order? Hearing none, I'll call the roll. Commissioner Bostelman.
Aye.
Commissioner Glancy.
Aye.
Commissioner Knudsen.
Aye.
Commissioner Spindell.
Aye.
Commissioner Thompson.
Aye.
Chair votes aye. We will continue. Are there any other points of order, Mr. Santeller?
No.
You may proceed with your arguments. Commissioner Administrator Wolf, if you would return the clock to 10 minutes. Go ahead, please.
Thank you. As I note in the first count of my complaint, Wisconsin statute section 8.202B contains a general requirement for most independent candidates for office that their nomination papers merely include a candidate's mailing address. However, the statute sets forth a different requirement for presidential candidates, that they state their residence and post office address. Now, while the parties may disagree on what this actually means in terms of the word residence, it has to mean something more than a mailing address, in my opinion. Otherwise, the legislature would not have parsed this out and made it a requirement separate from the mailing address requirement that applies to all other candidates. So in this case, even accepting the candidate's version of events as true, he only provided the mailing address of his campaign. While this might be enough to satisfy the statute's generic requirement that applies to non-presidential campaigns, this is a presidential campaign, and there must be something more contemplated by the statute than a mailing address. To me, and I believe under the law as well, residence means the place that you live. This candidate does not live at the address he provided, nor do his nomination papers indicate that his residence happens to be in that same municipality. Instead, his filings are asking the commission to make that inference, and I don't believe that inference is provided for by statute. That inference being that some unknown portion of the mailing address he did provide happens to also be his residence. Now, beyond that, even if a candidate could satisfy the residence and post office address requirement by simply stating their mailing address, which happens to be the same city as their residence, we don't have a verified statement from the candidate challenged on where his residence actually is. So I understand the commission is not considering my reply brief, but the Elections Administrative Code section 2.053 permits the commission to consult maps, directories, and other extrinsic evidence to ascertain the correctness of any information on a nomination paper. So if the commission is not going to review my reply brief, in which I suggest that respondent owns and may reside in at least 2 other pieces of residential real estate that are outside of Cody, Wyoming, I would implore the commission to exercise its 2.053 authority to consult extrinsic evidence to ascertain the accuracy of the residence stated on respondent's nomination papers. I dispute that the case law cited by respondent helps his cause in this situation. I don't think he cited to a case that limits the definition of residence to a city or state. So that is my point with respect to count 1 of my complaint. And I'm happy to get into count 2, which relates to the timing of respondent's filing. But I'd just like to raise another point of order with respect to that. I understand the decision that was made with respect to the other complaint on this same point. So I don't want to belabor the point. I'm happy to make a record of my own arguments on that. but I just want to make sure the commission is still entertaining that question with respect to my complaint.
Okay. We will be ruling on your motion irrespective of our previous ruling.
Okay, thank you. As to the timing of respondents filing, I don't think there's any dispute. The nomination papers were filed after 5. Even the candidate's own version of events, the filing was not in the hands of the commission until 5 o'clock plus 14 seconds. And I think respondent is relying on a strained interpretation of the statute, which reads no later than 5 p.m. I think they're asking the commission to rewrite that statute to read not later than 5 p.m. plus 59 seconds. That's not what the statute says, and it's not how it should be applied here. And as to whether the commission ratified respondents' filing by physically accepting the papers, I don't think that that's the case. Even respondent admits that commission staff openly expressed concerns about the timing of the filing, which to me suggests against the ratification having occurred. But beyond that, the administrative code at 2.053 gives the commission the right, after papers are filed, to, quote, review all nomination papers filed with it to determine the facial sufficiency of the papers filed. Now, in my view, there can be no more facial of a deficiency than the time at which a time-limited document is filed. There's nothing in the law that supports an argument that the commission's initial demeanor toward the filer is somehow forever binding on the commission to accept an untimely filed document. But if it's respondent's position that the commission made an error in accepting an untimely filed document, I think that the process should begin to correct that error to the extent any such error was made, which I don't concede. I think if the commission were to accept this logic, that any number of statutory insufficiencies in a nomination paper could be cured simply by handing that paper over to the commission. I think that the statute, which allows the commission to review papers after they are filed, encompasses a review for timeliness. And as to the commission's own safety measures, I don't think those are to blame for the late filing here. I think every other candidate and the challengers here had to deal with the same time constraints for filing and the same access procedure to get into the building. And it was only respondent who failed to deliver the papers on time. And at the end of the day, I don't think any of the mitigating factors suggested by respondent, such as momentary physical obstruction or having to call to enter the building, would have mattered had they simply done what every other independent candidate trying to get on the ballot had to do, which is afford themselves adequate time to get their papers to the commission in the 5-week time frame given to them by statute. They did not do that here, and I think their filing should be stricken as untimely. As to the third count of my complaint, which addresses specific page numbers containing circulator statements of address, my reading of the commission staff analysis and recommendations is that the pages I referenced in my complaint were already stricken, save for one. So I believe this issue to be almost entirely moot, and I will not be advancing any re-argument of those issues here today. I'll stand on my complaint with respect to that count.
Thank you. Attorney Curran?
Good evening now, Madam Chair and Election Commission and staff. As to the complainant's point on his first argument, I think that the brief that was submitted on behalf of Mr. West and his partner and his co-candidate speaks for itself, and we rely upon both the arguments made there and also the determination of staff that the high burden of clear and convincing evidence was not presented, and that the presumption of validity of papers filed should be, that the burden should be agreed to be met in this case, and that the complaint should fail. With regard to the timeliness, I'll restate my opinion that a timeliness challenge on accepted papers should not proceed under Election Code 2.07, but should proceed under Wisconsin Statute 5.06. And therefore, I believe that he's deficient in that he's proceeded in the improper venue for challenging a determination of the filing officer. That said, I also think that he fails to make the substantial clear and convincing evidence standard on the challenge itself with regard to timeliness, with just some extraneous information coming from video of one newscast or something like that. And that simply does not meet the standard that should be necessary to disqualify candidates who have taken steps to file papers with no supporting evidence besides a report. And I guess I don't need to address the third point. I don't think it's important, but certainly with regard to the timeliness, the complaint itself needs to pass the threshold burden, and I don't think it has in this case.
Thank you, Mr. Curran. Do the commissioners have questions for either Mr. Santeller or Mr. Curran? Okay. Do the commissioners have questions or requests from Mr. Judnick to offer opinions on any matter that is before us with regards to Mr. Santeller's challenge? Yes, Commissioner Knudsen.
Well, in the staff memo here, the case is made that we should reject the timeliness challenge because the complainant's case is not strong enough to meet the clear and convincing evidence standard. But my question goes back to our previous deliberation on the other complaint. Were we to enter into evidence all the same facts that we did during that hearing and carry them over here so that we ourselves established a record of a timeline of what in fact happened, then I think that evidence would greatly strengthen the complainant's case. So again, I kind of pose a procedural question here. I mean, I know I did it last time, but I don't know that we need to swear in and all of that again, but fact is we did bring out some factual evidence in the course of the proceeding here. Could you comment on that, Nate? If you were considering everything now all in one, would this staff memo look different?
Oh, yeah.
I'm sure it would, but that's not how these generally work. I mean, these are individual complaints and responses, right? So, and it's based on burden shifting. So, you know, based on the staff's assessment, you know, the burden did not shift to the complainant or to the respondent in this case, where a response would necessarily even be, you know, required. So the recommendation is that if the commission finds that based on the face of the complaint that the burden had not been met, then the burden has never shifted to the complainant, and additional evidence, you know, from the burden shifts from the complainant, I'm sorry, to the respondent, you know, then, you know, it's a different kind of scenario procedurally. So that was the basis of it. If you find based on, you know, what the complainant, you know, included is clear and convincing, then I think you know, it's different. Then I think the memo would go through, okay, what is the countervailing information that was provided by, you know, the respondent here, and you would go through all those, you know, same kind of machinations. But you know, based on the recommendation here, where we take these, you know, one by one, that is why, you know, that's why I didn't think it was necessary in this case. I hope that makes sense.
If I may, Madam Chair.
Thompson, go ahead.
You know, what I thought was important about this, and this is addressed to Mr. Knudsen, is, you know, it's at page 5 where the staff says, in quotes, a news article stating that a candidate's papers were not timely filed simply does not meet the burden of proof. And I think that's the issue. I mean, we don't want to set a precedent that if there's a news article that says someone's late, that's sufficient, clear, convincing evidence. I mean, I think that's a sound recommendation. Clearly, if we incorporated all the facts that we know, the decision would be different. So we can say that this complaint is denied because he didn't do it, and we can still say that it was untimely going forward, just so everyone knows. don't send us a complaint with just a news article.
Madam Chair.
So I have a somewhat different view about this, which is as follows. If, for example, the staff were to miss something glaring in their evaluation of papers, Mickey Mouse is the circulating person who circulated the nominating papers. Somehow they missed it. And the challenge says, I don't think Mickey Mouse was the circulator, without anything more. I don't know that as a commission, we would be obligated to ignore the fact that Mickey Mouse was very clearly not a circulator, simply because the challenge itself didn't have an affidavit from Minnie saying Mickey was elsewhere. In this case, we have a motion to strike the papers as untimely. We have already just ruled they are untimely. And I think we're placed in a rather perplexing position to then say that we're going to deny the challenge because the evidence as originally presented didn't rise to the level, even though now it does. And I think it is a struggle to ignore everything that this commission has simply gone through for the past 2 hours to do that. So I am troubled by the idea that, you know, if we look at 2.05, which says we're allowed to look at extrinsic evidence, we have a whole lot of it now, why we wouldn't do that. And I recognize what staff did here, which I think is right, which is there is some moderate level at which a complaint has to be sustained, but I don't think we're bound by that at the point where we have all of this information before us to then say no to the challenge when the challenge appears, based on our previous vote, to be an accurate one.
So if we're going to incorporate the rest, then you or Dean suggest the motion, because it would have to be modified to include and incorporate all the testimony and facts of evidence that we've decided to date, and based on everything, it was untimely. If you're trying to avoid an inconsistent, press release of this, which I could see, that makes a lot of sense, because people may not read between the lines and understand the nuance. So I would be comfortable with going that way too. I mean, clearly they were untimely, and we decided that already.
So I think the motion I would make would be, based upon the record of the proceedings held before this commission today, including the testimony of the Wisconsin Elections Commission staff members, the commission sustains the challenge to all nomination papers submitted by Mr. West and Ms. Tidball because they were not filed timely in accordance with Wisconsin statutes 8.20 sub 8 sub AM, and therefore their names shall not appear on the 2020 November general election ballot as independent candidates for the president and vice president, respectively, in Wisconsin. Commissioner Knudsen.
Might be splitting hairs, but Mr. Santeller didn't challenge Miss Tidball.
I will accept that amendment. Is there a second?
Sure.
Okay. Is there a discussion on that? Commissioner Spindell.
Yeah, I'm not going to go and repeat everything that I repeated before, but I'm not sure the example that you gave was a good one, because if we go back to December 2011 with the Scott Walker petitions, Mickey Mouse and Adolf Hitler were allowed to be counted on the recall petitions, as long as they were properly dated and included a Wisconsin address. So I think Mark has a lot of good points here, that we should not base something on a news report that would start it to be a very bad precedent. So I would be against, I would originally go with a recommended motion of the staff and not change that.
Obviously, those petitions were not before this body. Any other comments from the commissioners? Commissioners Bostelman or Glancy, do you want to be heard? I just think we need to be consistent and we can't ignore the evidence we've heard. It would be a rather bizarre ruling for us to do that. All right, any other discussion?
Is there a motion on the floor at this point?
There is.
What I'd like to make a friendly amendment again, that since the motion 1 be considered after motion 2 and 3, the 2 and 3 be combined into a motion, and then 1 be the second motion.
Well, I already made 1 as a separate motion.
Okay, and what I'm doing is a friendly. Oh, you're just doing number 1, right?
I am only doing number 1.
Oh, okay.
And it reads. Do you want me to read it again, Bob?
No, that's fine. And then you're going to go on to 2 and 3. Is that it?
No, Bob.
Okay, that's fine.
Bob, I'm not making the written motion.
Bob, there's a new number 1.
I know that.
Okay.
Okay. All right, so the recommended motion is based upon the records of proceedings held today before this commission and the evidence presented. The commission sustains the challenge to all nomination papers submitted by Ms. Tidball because they were not, Mr. West, because they were not filed timely in accordance with Stat 8.20 sub 8 sub AM. Therefore, their names shall not appear on the 2020 November general election ballot as independent candidates for president and vice president, as candidate for president in Wisconsin. That is the motion. Commissioner Bostelman.
Aye.
Commissioner Glancy.
Aye.
Aye.
Commissioner Spindell.
No.
Commissioner Thompson.
Aye.
All right, the motion is carried 5-0.
You're not.
5-1, excuse me.
Okay.
You are correct, Mr. Spindell.
Madam Chair,
Yes.
I'd like to move that we adopt the staff recommended motions on page 6 and 7, numbers 2, 3, and 4.
I'll second that.
There is a second. Is there further discussion?
Yeah, let's. 2 is the timeliness. Dean, we just changed it.
Oh, I'm sorry.
I think you meant.
I misspoke.
I think you meant 1.
1, 3, and 4.
Right.
Yeah. Okay.
Okay, so it is numbers 1, 3, and 4. And there's someone seconded that?
I did. Mm-hmm.
Okay, Commissioner Spindell seconded that. We will call the roll. Commissioner Bostelman.
Aye.
Commissioner Glancy.
Aye.
Commissioner Knudsen.
Aye.
Commissioner Spindell.
Aye.
Commissioner Thompson.
Aye.
The motion carries 6-0. All right. We will now proceed to the final challenge, which is the complaint of Alan Arntzen against the Wisconsin Green Party, Howie Hawkins, and Angela Walker. It is my understanding that Attorney Mandel will be presenting for the challenging party, and Andrea Merida will be responding on behalf of the Green Party, Mr. Hawkins and Ms. Walker. As with before, each party will have 10 minutes